Good afternoon, everyone. We are about to convene. Welcome to the 16th of October? Convening of the Board of Municipal and Zoning Appeals. Just a few housekeeping matters before we get started. If anybody has a phone, and most of us do, if you could just take a second, check your phone and make sure that it's on vibrate or off, just so that it doesn't disrupt the proceedings while we are moving forward. These proceedings are being recorded, and sometimes those phones going off can interfere with those recordings. So if you could be so kind as to just confirm or make sure that your devices are off or silent. After we hear the entire docket for the day, the board will deliberate on each case, and we will render a decision, in most instances, on each appeal today. You are more than welcome to stay after your appeal to hear the decision in your case, but if you have other obligations or you just don't necessarily want to wait around for the rest of the afternoon docket to complete, you can certainly call the board office tomorrow morning and find out what the decision was on your appeal. The number to call to find out the decision is 410-396-4301. Again, that's 410-396-4301. You will receive within about 2 to 3 weeks, on average, a written decision on the outcome of your case, and we ask that until you receive that decision that you not build or move forward with any of your projects for which you are here on appeal before you receive the appropriate approval from the board and the resulting permits that you will have to get after that approval is given. We are generally going to call the docket in the order that the cases appear on the docket. When the cases are called, the appellant, the moving party, will stand to my left, which is your right, along the dais, and the appellant will go first. You will present your case after you and all of your witnesses and anybody who is there or here in support of your appeal gives their testimony. The opposition, if any, will have an opportunity to speak to the board on their positions on the appeal. Anybody in opposition to appeal will stand to my right, which is your left. After the opposition presents its side, the appellant will have the final say. There will not be the opportunity for back and forth, just because for the purposes of efficiency and in fairness, the appellant goes first, the opposition goes second, the appellant gets the final word, and then the hearing will be concluded. Are there any? Nobody's asking for a postponement or anything today, is there? Okay. We will start with calling the cases on our consent docket. Now, prior to today's proceedings, the zoning board has reviewed the applications that have been submitted, and in some of these cases, the board has already determined that there is sufficient information provided in your written packet to approve your appeal without the necessity to have any kind of oral supplement to your appeal. So those cases are going to be called first. And why don't we start with, in the order that you are called, if you could line up from here in the middle to the left or your right of the dais, that would be helpful in keeping things a little orderly. The first case on the consent docket is 2018-329, 2100 East Fayette Street, Adam Carballo. Second case on the consent docket, 2018-330, that's 2102 East Fayette Street, again, Mr. Carballo. And third case on the consent docket, 2018-331, 827 North Calhoun Street, again, Adam Carballo. Next case on the consent docket is 217-335, 1 West Biddle Street, Joseph Anderson.
Should be 2018.
Next is, I'm guessing that's 2018, 338?
That's correct.
211 South Ann Street, James Abrino. Forgive me if I butcher any names. Next on the consent docket is 2018 340, 5603 Narcissus Avenue, Juan Caseta. And then finally, we have 2018-341, 3233 O'Donnell Street, Nate Prettle. So if everyone could raise your right hands and be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
First, we have, and these are all related, your first three, correct?
The first two are related.
The first two? Okay, so we'll call together 2018-329, 2100 East Fayette Street, and 2018-330, 2102 East Fayette Street. We have these as both petitions to construct a one-story detached rear one-car garage. Is that correct?
That is correct.
Okay. Are there any staff reports or comments from planning on those?
Martin French for the Baltimore City Planning Department. Planning Department has reviewed both of these applications and has no comment. Thank you.
Okay. Mr. Carballo, is there anything that you would like to provide in support or in supplement of the appeal?
No, ma'am.
Okay. Then zoning board staff, having previously reviewed your application, has already determined that there is sufficient information to approve your appeal, so
Thank you.
those two have been approved. Next, we have 2018-331, 827 North Calhoun Street. We have that as a request to use as 2 dwelling units. Is that correct?
That is correct.
Staff reports or planning
Yes.
position?
Planning Department has reviewed this application, notes that this property is located within the Harlem Park 2 Urban Renewal Plan area, and therefore is recommending that approval of this application be subject to the condition that all exterior improvements or alterations to the structure are completed in accordance with plans approved by the Department of Planning. Thank
Okay.
you.
And is that acceptable?
Yes, it is.
Okay. Zoning board staff, having previously reviewed your application, has determined that there is sufficient information to approve that particular appeal as well. Good luck to you.
Thank you.
Sure. Next, we have 2017-335, 1 West Biddle Street, Joseph Anderson. Are you Mr. Anderson?
I am.
Okay, good morning, good afternoon.
Good afternoon.
We have this as a request to use portion of first floor as beauty salon. Is that accurate?
That is right.
Okay. Are there any staff reports or planning comments?
Yes, Planning Department has reviewed this application, noted that this property is within the Mount Vernon Historic District, and therefore recommends approval of the application be subject to the condition that all exterior changes, including additions, demolitions, alterations, and signage, are completed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Okay. And are those conditions acceptable?
Yes.
Okay. Planning, having imposed those conditions that you are agreeing upon, the zoning board staff has approved your appeal with those conditions in place.
Thank you.
Next is 2018, and thank you. Next is 2018-338, 211 South Ann Street, James Abrino.
Yes.
Okay, are you Mr. Abrino?
Yes, I am.
Okay, welcome. We have this as a petition to construct second floor rear addition with rear balcony and construct rooftop deck. Is that correct?
Correct.
Okay. Staff reports or planning?
Planning Department has no comment on this application. Thank you.
Okay, thank you. The zoning board staff has already previously determined that we have sufficient information to approve your appeal. Is there anything that you would like to submit in supplement to that, or are we? Okay, thank you very much, and congratulations. Next, we have 2018-340, 5603 Narcissus Avenue, Juan Caseta. Okay, we'll pass that one. And last but not least, 2018-341, 3233 O'Donnell Street, Mr. Prettle.
Good afternoon.
We have this as a request to use portion of basement as office. Is that accurate?
That is correct.
Okay. Any staff reports or comments from the planning department?
Yes, Planning Department reviewed this application. The floor plan that was originally submitted available to planning staff was not very clear. The applicant has provided additional information showing that this property would have the office entrance directly on one of the principal streets that this building is at the corner of. The department therefore recommends approval of the application. Thank you.
Okay, thank you. Are those conditions acceptable?
They are, and I would actually like to submit the additional information. When the application was submitted, I just showed the basement floor plan, which showed a fire exit door to a rear alley. This clearly shows the primary entrance on O'Donnell Street on the first floor, which then leads down to the proposed office space. And I'll add that for any of the board members, Madam Chair, I believe it's just you who were here for the last time that this appeal came before the board to use an apartment building. My client has since done a really wonderful historic renovation of the building, and it's ready to open, and this will just be in addition to that.
Okay, very good.
Great, thank you.
Thank you, and your request has been approved. Thank you. Next, I'm going to call someone just came in. Would that happen to be Mr. Caseta? Okay, just wanted to double check. All right. It's okay. Next, we're going to call just two matters where opposition has signed in on those two petitions. We'll ask that you, at this point, just stand where you are so that you can recognize the appellant and the opposition, and I'll ask you if you want to speak to try and resolve any differences that there may be regarding the two opposing sides. We like to give you an opportunity to talk with your opposition because we find that, generally speaking, opposition is often the result of either no communication between the parties or a miscommunication between the parties. So we'd like to give you an opportunity to see if that can be resolved before a full-fledged hearing is conducted. So if you'll just stand in place, we've got 2018-316, 728 Colorado Avenue, which is Nate Prettle. And who's here in opposition for that?
They're in the hall now.
They're in the-
Mr. Berry is in the hall with some of the opposition.
Okay, and, okay, we'll let them continue to chat. It's good that they're already taking advantage of the opportunity. And the other case where there's opposition signed in is 2018-323, which is 1000 Eastern Avenue, also Mr. Prettle / Mr. Berry, I'm guessing. And-
Ms. Blatterman has spoken to Al Berry as well. I don't know if your opposition still stands or
Is there a desire to either talk or continue to talk if you started
Yes.
that process with the Eastern Avenue project?
We'll continue.
Okay, very good.
I think they already had a chance to speak. So we're fine.
Okay. Okay, we're going to jump around just a little bit in the interest of,
Time management.
yeah, time management and being fair to the litigants who don't necessarily have lengthy hearings anticipated. Calling first 2018-332, 6600 Cleveland Avenue, Dino LaFiandra. We have this listed as a request to use basement and portion of first floor as office and use remainder as 4 dwelling units. Is that accurate?
Yes.
Okay. For all of those who are going to give testimony, if you could raise your right hand and be sworn.
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth.
I do.
I do.
Okay. So if you could just, let's give planning and staff reports priority here, and then we'll hear from you. Are there any staff reports or comments from the planning department?
Planning Department reviewed this application The key, basically, to the Planning Department's recommendation of disapproval of the application comes in two parts. The first part was that the proposed commercial use as an office is a prohibited use in the R3 zoning district where the property is located. And the issue there is a change of non-conforming use, whether the property was previously used as some other type of non-conforming use rather than an office. The second issue involves the number of dwelling units in the property itself. A multifamily dwelling structure is a non-conforming use also in the R3 zoning district, even though this structure was actually built deliberately as a multifamily building, which the Planning Department would note for the board's benefit. And it, at one time, did have 4 dwelling units in it, also noted. However, its current use, according to information available to the department, is 3 dwelling units, not 4. And therefore, again, the board is confronting the issue of an expansion of a non-conforming use, which is something that the zoning code does not authorize. So for those technical reasons, the department recommended disapproval of this application. Thank you.
Yes, ma'am.
So if you will tell us about your project, and in describing what you are intending, if you can address the 2 concerns
Sure.
that
If I
Mr.
may,
French raised.
My name is Dino LaFiandra. I'm an attorney, and I represent Ross Huff, who is a member of the LLC, which owns the property.
Okay.
And just to start, we're at 6600 Cleveland Avenue, and if I may, I'd like to just show you a photograph of the property. Thank you. This is a shot of the property from the intersection of Cleveland and Central. There you are.
Thank you.
have. And this is more straight on, just from Central Avenue, showing just the side of the building. There you are. Thank you. They show, it's just a different perspective of basically the same side, right there. I wanted to, before we start, I wanted to make clear, no part of this application deals with the basement. It's only the first floor and the second floor that we're talking about.
Okay.
The basement is basically empty. It's some storage space down there, but there are no apartments, and there's no proposal to have any apartments, and there's no proposal to have any office space down in the basement.
Okay.
The top floor of that apartment building that I've shown you the picture of consists of 2 dwelling units. The first floor has 2 dwelling units. If you're looking straight on from Cleveland, there's on the right side, there's 1 dwelling unit, and on the left side, in the front, there is a vacant, we'll call it a commercial space, and in the rear of the building, there's a occupied apartment in the rear of that. This is a floor plan of the second floor, if I may. There you are. That's a floor plan of the second floor. That shows the 2 apartments on the second floor.
Oh.
For you. And then, just to round out the exhibits quickly, this is, I'm handing out, this is a floor plan of the apartment on the first floor, and I apologize, I only have one copy of this. And this is the vacant commercial space on the first floor, and this is the smaller apartment in the rear of the first floor. Mr. Huff and his partnership bought this property about a year ago in the late summer of 2017. This building was built in 1955 as an apartment building in a section of the city, and it's right on the Baltimore City-County line in Dundalk. And it's in a community that is predominantly single-family detached houses. So there's a multifamily building that is suitable really for 5 units in a part of the city and the county where it is predominantly single-family detached dwellings. The first floor, the commercial space, has been used in the past by authorization of the board as a daycare facility, either for 15 children or at different times for 30 children by approval of the board. Mr. Huff bought the property after inspecting it, and it appeared to him at the time that there were 4 apartments on the property and this vacant commercial space. He did check, he had an opportunity to look in the basement, and he saw that there were 6 electric meters. And you'll see in the zoning history of this case, in 1991, there was a case. This is a photograph that Mr. Huff recently took. There's a virtually exactly the same photograph in 1991. And what I'm saying is that the property has been served by 6 electric accounts for at least the last 20 years or so, and most likely longer, considering the age of how the meters appear. And when Mr. Huff bought the property, he did so. There was an existing multifamily dwelling license at the time, which I have a copy of for you. And when that one expired, he got another multifamily dwelling license, which is currently, if I may, thank you, which is currently valid. So what we have is a situation where
It's okay.
my client bought the property after inspecting it and under the impression that it was suitable for 4 units, and and only to learn on a subsequent inspection that there was an issue with the density. So we understand the position of the Department of Planning as it relates to the continuation of the non-conforming use and whatnot, and the density issue. But we are coming to the board to ask for a little bit of equity. There is an issue here as it relates to how it appeared to Mr. Huff when he toured the property before, at the time of buying it, what the indications were to him as to what the property might be used for, and also, of course, he wasn't knowledgeable about this at the time, but the report from the Department of Planning in 1991, I wrote a letter last week, it should be in the file. I included a copy of the report from the 1991 zoning case, where then the owner of the property came in looking for approval for 5 units. The board turned that down, but the Department of Planning at the time did support 4 units, and their report, which I attached to my letter, indicated so. I'll hand that in. They noted in their report several of the items that I just commented on, particularly regarding the fact that the property was built as an apartment building in 1955 in a predominantly single-family detached neighborhood. It appeared to them at the time that it would be unfair to restrict the applicant to the number of units. I think it was 3 at the time. He was looking for 5, but they thought that it would be more appropriate to let them have 4. And frankly, that's all that Mr. Huff is looking for right now. And as it relates to the commercial space, the request really was just so that there was not some idle space in the unit. If it was, there's no intention to have that commercial space be a nuisance or an annoyance to the community, only a convenience. He'd like to rent it to like an accountant or a lawyer, somebody who needs an office for a pedestrian oriented use, not something that requires cars or anything along those lines.
Is this attached to that? I just want to, it's already copied.
No, this looks like it's just what he's doing.
That should have been attached, yes.
Oh, here it
like for this to
No, I-
be made a part of the record?
You might as well.
Oh, okay, it's already,
Yes.
it's in the back.
This issue came about because when Mr. Huff was having an inspection for his multifamily dwelling renewal, the inspector commented on on a discrepancy between, when apparently there was some discussion between the zoning office and the inspector, or the code enforcement office and the inspector, on the number of units that were authorized when she
Okay.
was there. It appeared to her, she had inspected the property before, and it seemed odd to her that she had to even create it as an issue. But there are 4 units there when he bought it. He hasn't made any changes to the property, and all he wants to do is continue with the 4 units that are there.
Council, is the office space still a part of your appeal?
Yes.
On that first floor?
Yes.
When was the last time that was used as a office?
I don't
The
believe,
corner space.
Yeah.
It was used as a nursery last. I just think that's not a good idea for involved. It was 15 or 30 children. And
Do you have any idea how long ago that was?
I don't know when they stopped.
so
How many people are living in the building now? Anyone?
there are 3 of the 4 units are rented out.
Okay.
Yes.
And so the one first floor unit and where the daycare used to be are now vacant?
Yes.
Well, it's the long one.
The long one on the right
On-
side of the building, sort
so-
of the side you can't see as well on there.
Right. The
yes,
smaller unit in the
is the
back.
corner.
The smaller unit in the back, behind the daycare unit, is filled. The daycare unit is empty, and the longer unit along the side of the building is empty.
Okay,
The other 2 units up top are filled.
got it.
So if approved as office, it couldn't be commercial? I mean, there's absolute distinction. Let me ask staff. Eric, if approved as office, there could not be commercial use. Is that correct or not?
So, an office use would be considered a commercial use. The problem with this particular property is that it's located in an R3 district in which neighborhood commercial for offices would not be permitted. So in order to get the office, you'd have to show that there was some non-residential use ongoing in that commercial quote-unquote space before, up until 12 months ago, for the office portion, not the dwelling units.
Right.
The dwelling units are a separate issue.
As it relates to the dwelling units, it is important to note that the 4 dwelling units, there's been no change whatsoever to them. They existed when he bought the property last year, and they continue without any alteration since then.
Okay.
It's super strange that the dwelling license was only issued for 3,
Right.
considering you were approved, since zoning approved it for 4. But yeah, it doesn't,
Yes, I don't understand, yes,
okay.
yeah.
Any other questions?
No, I'm good.
Thank you.
Thank you so much.
Thank you.
Next calling, 218-333, 701 South Bond Street, Nate Prettle.
It's back there.
The other one.
Yeah.
Would you like a little more time to chat, or? Are we,
No, I think
we don't want to rush you if you're making progress. Okay. So we have this listed as an appeal to use second and third floors as private social club. Is that accurate?
That's correct.
Okay. If all of those who are giving testimony can raise your right hands and be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the whole truth and nothing but the truth?
I do.
Okay. Are there any staff reports?
I have nothing.
Planning Department has no comment on this application. Thank you.
All right, gentlemen, if, Mr. Vieri, are you taking the lead?
Okay, so this is a request to convert the second floor of an existing bar, tavern, restaurant in Fells Point to a private social club. We previously gave the board, don't know whether it's in your files, a copy of recommended bylaws is required.
We have those.
Okay. We've met with the neighborhood association about this. We have the operator of the bar below here, and I think you're going to testify, is that right? Yes. As to the operation and the intent behind this club. We met with the neighborhood association, and Mr. Prettle, do you want to talk about that?
What's the bar? The name of the bar? Huh?
Sir Duke used to.
Sir Duke's.
701.
Before we answer questions, I need names. So what's your name?
Brian Burkert, B-U-R-K-E-R-T.
Burkert.
Mhm.
Brian with an I.
With a Y.
Before I go in the community. Your name, ma'am? Andrea.
Just want to talk about the use of them. Why don't you, do you want to get up and just describe how you plan to operate the
second floor?
second floor?
The second floor is going to be a private lounge, and we're going to allow medical marijuana patients up there. And you will need a state ID, medical marijuana state ID. All the same provisions that are in place for cigar lounges in terms of sprinkler system, clean air return, everything will be in there. There'll be a monthly fee to be part of it. To get your state ID medical marijuana card takes a minimum of 3 weeks just when you sign up with the state. Then you have to go through a doctor. So it's not something we're just going to be able to turn around and say, oh, you're part of the private club right away. We're not going to sell. Obviously, you don't have the right to sell or anything. It's just a place for people to, patients to take their medicine. Because if we look at the reality of things in Baltimore City, if you have a medical marijuana card, you can't, there's plenty of apartments, buildings where you can't smoke. You can't smoke in your car, you can't smoke outside, and you can't smoke in your workplace. So right now, I don't think it's a great business to start a business that's only got 40,000 potential customers in the state, but it is the second floor of the bar, so we're going to take a chance on the usage of it over the long haul. I'm going to have to take the second floor of the bar off the liquor license, so that'll be removed. So, any questions?
So what's the intent for the third floor? Because the proposal says to use portion of second and third floors.
The
as
third
private
floor
social club.
is a little deceptive because, has anybody ever been in there when it was Fletcher's or the Get Down too? It's already been gutted out.
Okay.
So when you think, when they have the third floor, it's just a small little, would have been backstage area. Maybe it's 20 by 8.
Okay.
So it's a balcony that's kind of looks over. There's not really a third floor there anymore. It's already been ripped out to the roof line.
Okay. But the intended use of that space is the same as what you're calling the second floor?
Just like just to carry through the lounge area.
Okay.
And probably just have more peek down at the space below, because the
Okay.
balcony's over now, similar to out here.
Got it.
What days and hours are you intending to be open?
We were looking at the same hours as the bar, till 2.
And then how are you going to make sure that guests are legally able to use?
The same database that the dispensaries use, we would have to subscribe to that, which you can get a subscription. Somebody comes up, as it is now, you don't necessarily need your medical card. You need just your driver's license, and then they log in, and you have to make sure you're current when you log in.
Is someone going to be working the door?
There'll always be somebody at the front door to get into, at the second floor entrance right there. I mean, for myself, this is my wife, we own the building, so there's inherent risk in doing this. There's an inherent risk for me to take away part of my liquor license, which I've had for 20 years there. There's an inherent risk that the federal government, with Jeff Sessions, may change his mind and come after my building and stuff like that. But I believe in marijuana as a medical product. I use it for myself for arthritis, and my daughter uses it for stomach issues. So it was kind of like, for me, a risk worth taking. And it'll be the first one in the state, and it's something different for Baltimore. I own the Soundgarden. I've owned the Get Down. I own Fletcher's. I own the Rockwell. I started, so we've done a lot of different nightlife in the city and done a lot of different things. So this is sort of a risk and a chance, but I think we'll do it well and professionally.
What's this gonna look like inside?
Um,
Will there be refreshments or?
Yeah, we'll still have refreshments. There's still a bar on the second floor. It just won't be serving liquor. We foresee it having a lot of events with the dispensaries. Some of them education events, some of them social events, and things like that. Because we really have to figure out a way to gather, of the 40,000 people spread out through the entire state, how are we going to generate enough people that are even going to come into this space? So a lot more like social and event-based based evenings than anything else. I don't even know how much business we'll be able to get during the week. There's a kitchen already there that's going to be sealed off and attached to that, but that's already in place.
Will that be operational?
Yeah, the kitchen's already operational, but the kitchen belongs to the bar, so then the kitchen will be able to cater food, deliver food to the space.
Okay. And will guests, or I guess members, be permitted to go between floors to partake
They won't,
of
no,
the
no.
bar part of the?
Yeah, of course, but they won't be able to bring, think of it as two different businesses running in one building. So they won't be able to take their drinks from the bar into the lounge, and of course, they won't be able to go downstairs and smoke in the bar.
I have a question. With regard to the use of the medicinal marijuana, does that use have a permitted quantity?
There's a permitted quantity for the patient. The patient can buy this much of it. Do we have a permitted quantity for somebody to use? I don't think so.
Well, in terms of,
Marijuana itself has a built-in permitted quantity. It's not like it's not like you can drink as a gallon of Jack Daniels. You can't smoke a pound of marijuana without passing out.
so will you have limitations on the amount of marijuana that will be allowed to be imbibed at your facility when somebody comes in? For example, would they be able to bring in their quotient of permitted purchase? Could they bring in a gallon,
Could they bring in a
quarter-pound?
wheelbarrow of marijuana? That's a good question.
that's
Nate?
why I asked, yeah.
My answer to that would be that they can bring in as much as they are legally permitted to possess at one time. I think, as Brian said, why someone would feel the need to bring in however much marijuana that is to use in that day, if they really need it and for medical reasons, I don't think they would stop them, but I don't necessarily think that that's a likely scenario.
And let's keep in mind that every person, it's not like we're not looking for people to, it's not a seller's market. If somebody was like, oh, I can pick up I just picked up 2 ounces of marijuana from the dispensary, let me go to the place where other people who go to the dispensary are gonna be. I mean, that's not really, if that's where this is heading, is if.
My question is simply, one, I don't know what the permitted quantity is that one can purchase.
That is, that's limited by the doctor they have. It's usually 1 ounce of what they call leaf, like actual marijuana, and then like 2 to 3 grams of the oil.
Okay, and so an individual who has that particular quantity that they're allowed to purchase,
Mm-hmm.
who polices when that individual comes in to your facility, whether or not they have that amount or more? I'm just looking at whether or not somebody has the ability to go beyond what they're legally permitted to purchase to use in your facility.
We're not gonna, we don't have anything in place for that. And the legal amount that they're allowed to purchase is for a month, is a 30-day supply. And they could buy that all at once.
Sure.
So it would be like having a social club that allows you to bring BYOB and you bring your own liquor. You bring a six-pack. Well, that doesn't stop you from bringing a keg, but why would you, you know?
So will your clients or whatever, will they be able to share what they bring in?
Technically, by the bylaws, they can't, correct?
The bylaws, they're not allowed to share. Well, no one who isn't registered with the state can come in at all. You know, if someone wants to share with another registered patient, I don't think that there's anything under the state commission guidelines or our bylaws that would prohibit that. And in getting your question whether that's a negative thing or not, you know, the board has the ability to place conditions on that. But these are things that are great questions, but I don't see as, you know, practical issues within the social club.
Just two more questions. How many members are you gonna have? Are you gonna open it to?
We haven't put a cap on that. Obviously, there'd be a fire code in place, which will limit the amount of people we'd ever be able to put up there. I don't know if, you know, first we have to get some members. Obviously, we're not going to
Do you
keep.
know what the capacity is for the second floor?
The capacity for the second floor right now is 85.
85 people.
But when we say members, that would be somebody, it would be like members at a gym, you know.
Sure. You're not going to be all.
Yeah, they're not going to be there all at once. So if we had 1,000 members, the likelihood that all 1,000 would be there on the same day is fairly. We would cap it, from a business standpoint, we would have to cap it because people wouldn't want to not have the ability to go.
Right.
Why would they keep paying for a membership they can't get in?
So will there be a necessity to, I guess, make a reservation of sorts, or do you just show up when you want to?
Those
and
would
hope
be
that
all.
there's
Those would be
space
great
for you?
problems to have. I mean, I mean, let's look at the reality of this. How many? You know, there's 40,000 people who have cards in the entire state of Maryland. It's not that many people. You know, so
It's gonna grow. I mean, it just.
Yeah, it'll grow. I think it'll get to 100 over the next 2 years.
I think it'll get a lot bigger than that, based on what happened in Colorado. So.
But Colorado went recreational.
True, but there was still a lot of,
I think it was 5% it got to in Colorado. I mean, dealing with what we have right now, we don't have much of a market to put this out to.
okay.
And can you describe the physical changes you have to make to meet the indoor smoking requirement?
Yeah, and that's the other thing, because obviously you have to look at, once this door is open, other people are going to come to you to do this. I get it. So we have to we're putting a sprinkler system in, which is about a $100,000 investment. And then the clean air return system, which is $85,000. So for somebody to do this on the first floor of a building, it's just foolish. For, you know, there's not a lot of, to get the money back out of this is going to take some time, a lot.
And you looked at other examples around the country where this is.
Yeah, and this is, it's obviously, we tried to look at apples to apples, which would be Arizona, which also has medical and hasn't gone recreational. And there's a few of these that are starting to, you know, pop up. And let's be honest, I mean, the option of people drinking versus smoking marijuana for the effects that they have on a neighborhood aren't even close, you know? It's not like people are smoking marijuana and going and peeing on people's doors and stuff like that. It's not, the actual rowdy behavior and stuff like that much more comes from alcohol. And don't forget I own a bar below it, so I'm not exactly endorsing, you know, one over the other, but.
Storming a 7-Eleven nearby for some food on the way.
Any other questions?
Mr. Prudhoe want to talk about the neighborhood interaction?
Sure, very quickly, I just think it's important to mention that this was brought to the community at large. We made a presentation to the Fells Point Task Force, which is chaired by Delegate Brooke Learman, who should mention is one of the people responsible for enacting the state's medical marijuana laws. And someone who was born in Fells Point and spent the majority of their life there, I've never seen such a positive reaction to a land use or zoning proposal as I have with this. Take that for what it is, but just not having any opposition as well. And we also presented to the Fells Point Residents Association. And while we don't have any written support, I think the task force as a whole, as well as the Residents Association, speaking to the president this morning, did not have a problem with me characterizing their position as supportive, but they are also curious about how the city is going to handle not only this application as well as future applications that come forward. And I think we would urge you to support this, and we think it's a great use and an important use for patients who are registered with the state.
Okay. Anything else?
Neighbor. I own 713 South.
Step forward, and I don't think you were sworn.
I know I didn't. I apologize.
It's okay.
Raise your right hands, please. Ms. Splatterman, if you're going to testify, do you want to raise your hand? Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Your name, please, ma'am.
My name is Catherine Green Davis.
Okay. What would you like to tell us?
I recently purchased 713 South Bond Street, and I have lived at 708 South Bethel Street, which is catty corner to the back of Fletcher, or I still call it Fletcher's. And I've been Brian's neighbor over the years, and I've had intermittent, problems with noise is the reason I came down here. And now that I listen to this, I'm like, this is such a big can of worms, because I'm a nurse in the ER at Johns Hopkins, and I'm questioning the need for a social club to go smoke your marijuana. If your marijuana is for your health, then you would be satiate or diminishing the side effects of an illness. So if you're ill, you would be at home smoking your marijuana, trying not to be ill. And I get marijuana. I don't really think I'm totally down with medical marijuana. I see it helps my patients. I worked on an HIV unit for 2.5 years. I totally understand. But to go out to a club to smoke your medical marijuana is and then also this needs a bigger context, because this is the first one. Are there any other in Maryland?
No.
Okay, so this is the first one in Maryland. This is a precedent that will be set, and once you change the zoning, I think, and also as far as availability of marijuana is ubiquitous in Fells Point on the weekends. You can smoke pot anywhere, anytime. I smell it all the time. The lobby of the emergency room smells like marijuana all the time. And also, if you smoke a lot of this new marijuana, there is evidence-based practice about intractable vomiting, which we get young people at the hospital who cannot stop throwing up. And there's no drug that will stop them from throwing up. So they're dehydrated, and they're laying in, we have all these beds in the emergency room for alcohol poisoning, people who've been Narcan, and intractable vomiting. And I've watched the rise of this intractable vomiting, I can't even say the word, and I was like, when I was young, I'm not gonna lie, I smoked a lot of pot, and I never had that. And then also there are all these studies, a neighbor of ours, Dr. Elise Wirtz, is doing studies about withdrawal symptoms from marijuana. It's documented evidence-based practice about withdrawal. So, but my biggest concern is, why would you go out and also change the zoning of your building? And that is, I think, should not be passed and should be thought about with some great concern. And I have not been to the neighborhood meetings, and I'm a past president, but I'm busy trying to pay for my kids' college.
Okay,
All right?
thank you.
But I am really glad I came today.
I'm just here out of curiosity's sake here. Exactly, is there a variance that we're here for? You're saying a zoning change. We're not zoning change. Is this
No, it's a
zoning?
variance request.
What is
It's
the
a private
variance?
club.
But is it for a private club? Is
For a
that-
social club.
For a social club, and what are the standards? I'm questioning because we are the community next to this community, it's up the street, and I think these people are lovely, by the way, of course. I'm not opposing, I'm questioning because this is the first, and I'm curious what's happening here. You know, is it going to be a hospital or is it going to be a social club? I don't know.
Ms. Blatterman?
Yes.
For social clubs, they're required to submit bylaws and/or a charter, and those bylaws have to specify membership, how you become a member, any kind of dues that are owing, the organization of the structure. So
That's all that's in front of the board.
That's correct.
Yes.
It's not anything to do with the smoking or...
Correct.
that is correct.
The institution of the social club itself is what's before the board.
Okay.
I have one
I
more.
got you.
I have one more question.
Thank you.
Ma'am.
So is,
You gotta wait your turn.
okay, I
I'm sorry,
apologize.
Thank you.
I have to take a record of these proceedings.
Okay.
Right now, it's a little muddled, so go ahead.
Okay. And I actually have a question. Is there a physician who says you have a better outcome for your medical marijuana if you go smoking at a club?
But so again, what's before the board is for a social club.
I know, but it's a
the
social
legend-
club to smoke marijuana.
Yes, ma'am. But that's regulated by state law, not regulated by city law. So all we have the authority to do is to regulate whether or not a social club meets the definition of a social club, and all that other regulation is preempted by state law. So we can't touch any of that. So if they're not in compliance with state law, that would be an enforcement issue from the state perspective. I just want to give you an understanding of what we can authorize and what we can regulate and what we can't regulate.
Well, you also are a steward of the citizens of Baltimore, and I'm asking you as a citizen of Baltimore that this be not approved today so it can be thought about in a much more deeper context, because this is not very well thought out. Okay?
Okay,
enough.
thank you.
Thank you.
I had just one question about you said that you made a presentation to the neighborhood.
Yes.
Correct.
Do you have any letters indicating that they support it, or?
I do not. I can provide evidence that we had met with the community association. I think I'd mentioned that the Fells Point Residents Association, while Al Berry and I both spoke to the president this morning, had no problem with us indicating verbally on his behalf that they were in generally supportive of the idea, wanted to see how the city treated this, because this is a it's a
They
new.
wouldn't write a letter for you, is that what you're saying?
Well, to put, not to put words in David Martz's mouth, he said frankly they were going to send a letter, but he didn't realize the hearing was today and forgot to send it. But,
Would that be something you would be able to submit if we
Absolutely.
continue the matter today?
yeah, well,
letter
we
from
would
the
ask,
neighborhood?
that the board vote on this, but absolutely. And I should mention in regards to the young lady who was opposing this, that it should be well thought out. I would offer that, presenting to the Fells Point Task Force, including a state delegate who, had took part in enacting these laws, and the presidents of, I believe, 8 or 9 separate community associations, is going through the proper process. And
I appreciate that. I'm
Yeah.
just wondering why no one wrote any
Yeah.
letters. Given that this is the first and given what it is, I'm just
Mhm.
surprised that there aren't any letters from
That's-
any of those people.
We can get that.
Sure, we can certainly.
If I could just add, one of the things that, when we became involved with this, of course, as the first, we were concerned about any number of reactions, and so we wanted to be transparent, met with the health department, met with the police department, met with the communities, fire department, and we were surprised, almost, if you think about the dispensaries, when they started to be opened in Baltimore City, there was some initial consternation about, well, what's this going to mean? And frankly, they're there and nobody notices them, to my knowledge. It's been, people are saying, well, why not? Rather than this is going to be a problem. Not to say that can't be abuse of any substance or alcohol certainly, but we're trying to take steps so that it's limited to the people that are registered. We're trying to take steps so that there's no interaction between guests. That would be a problem, obviously in violation of state law. And then, Mr. Berger, do you want to add something?
Yeah, I think the one problem I have is that you can't just, if you need marijuana for, like, I have, my hands, like right now, they're okay. Now they're starting to shake, but are really bad. And I'll probably have to leave this facility and have marijuana at some point just to get the arthritis back from my hands. So to say that I always have to do this in the comfort of my home and I've got to be that's ridiculous, because I can't, the reality is I can't smoke it outside legally. I can't smoke it in my car legally. I can't go into somebody's restaurant and smoke it legally. And I'm not saying that this one space in all of Maryland is going to be the solution to this, but to deny that space, I don't think is also a solution.
I would just add one final note about letters of support. Unfortunately, this being, the use of marijuana, whether it's medicinal or not, is controversial, and people maybe at this point, especially the first one, don't feel as comfortable as they would be writing support letters as they would in other circumstances. And we hope, to address Ms. Strachan's comment, we could certainly provide that, but I hope when these come in the future, maybe the sort of discourse has changed a little bit and people won't feel as uncomfortable.
That's exactly why the letters are asked for, though.
Yeah.
Right.
Well, and Mr. Cunningham, I think if there was a level of opposition to this, I think the board certainly would have heard from some other folks.
Sure.
I'm looking at your posting, and it doesn't indicate what it's a social club for.
Correct.
And so if I'm walking by and I don't know what I just, that.
Well, but the neighborhoods know.
The neighborhoods did know, and I'm going to sit up here under oath and say that this was presented to not only the state 46th district delegation, Councilman Cohen's office is well aware, and the presidents of the task force. Fells Point Task Force was created as sort of a clearinghouse for issues that come to the greater Fells Point community, so that every organization is aware of it. And Brian and myself were there, I think, 3 Wednesdays ago, right after a presentation for the Broadway Market, which was, they gave them a much, much more difficult time than they did for this proposal. So I'll just leave it at that. I don't have anything else to present.
Anything further?
Nope.
So you're going to provide letters from the task force and the residents association?
I'm not sure the task force sends letters on issues like this. As Mr. Prudle said, they're a clearinghouse, but we will, Mr. Martz indicated he just forgot, so we expect to be able to get that to you shortly.
Yeah, and I don't think we're pressing on anything that other types of appeals don't
Right.
get questions about.
No.
Obviously, it simply provides evidence that that was in fact done, and there's no question about
No,
that.
we have
because
no-
we have the evidence.
We understand.
We're going to do it, let's do it right.
Sorry.
That's a good point. We'd be happy to provide that letter.
Okay, very good.
Thank you.
I'm sorry, we've already heard from the opposition.
Thank you.
Thank you. That's probably where we'll end up. Okay, next on our docket is 2018-334, 6701 Hollibird Avenue, Jose Serrano. Good afternoon. Are you Mr. Serrano?
Yes.
Okay. We have this listed as a request to use property known as 1801 Dundalk Avenue for sedan service. Is that accurate?
That's correct.
Okay. Do we have any staff reports? Cool. We'll swear you in before we take any reports from the staff. If you can raise your right hand to be sworn.
Raise your right hand. Do you you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay.
Sorry. Yes, Planning Department reviewed this application, noted that the requested use was classified by zoning administration as a motor vehicle operations facility, as limousine service or similar things are not actually listed that way in the zoning code. This property actually has two separate buildings on it. The applicant is proposing to use the portion known as 1801 Dundalk Avenue for the proposed sedan service operation. And the aerial photograph available to the planning department suggested some of the sedans may already actually be parked on the property, but parking them does not, of course, establish that there may already be a non-conforming use of the property as sedan service or motor vehicle operations. The department reviewed the other uses of the property and is recommending disapproval of the application because the zoning code does not authorize creation of new non-conforming uses, which a motor vehicle operations facility would be in this C1 zoning district where the property is located. Thank you.
Okay. So, Mr. Serrano, why don't you tell us about your project, including what's currently there and how long, if at all, the sedan service has been operating from this particular location?
And that particular location is about 2 years. And it's a sedan service. There is basically, we just occupy the office, nothing on. The parking is only we use when we buy a car and we're waiting for the documentations like registration and stuff like that. Nothing else. It's no people coming in, or we don't have customers coming in and nothing. We just answer over there, and that's all that we do over there.
So you're operating now?
Yeah, basically.
How many
yes.
cars do you have? Or sedans or whatever?
Sedans have about 30 cars, but none of them there in the parking lot.
Where do you park the cars?
Every driver has their own car. So I'm not on the cars.
So explain how the operation works.
The company operate by the independent drivers. Every single driver, they have their own car.
Okay?
So they don't go at the office and park in the car at the office. So, no, I mean, the company only have one car.
Okay.
All the other cars, there's under the driver's name.
So is it a call center where basically people are calling to make appointments?
Not appointments, they can call and send the car right away, whatever.
What is the space actually being used for?
Just to answer,
The phone?
yes.
Okay.
So if I want to call a car, I call you.
Call the
and
office?
You assign that to an independent operator.
Yes, we receive the calls and we send the job to the drivers. That's all. And the drivers, they never are at the office waiting for jobs. They always are in different areas.
Okay. Is there ever an occasion where at the end of a particular shift, those drivers bring sedans to your Dundalk Avenue location and leave them?
No.
This photograph shows 1, 2, 3, 4 cars in the lot when it was taken.
But there's not us, because the 1801 is attached with the 6701. So some of those cars is from them, some of them is from the people who lives upstairs. And I used to have 2 cars parking on the lot. I'm just waiting to junk the cars.
I don't get this.
So, Mr. Serrano, just
This is a limit.
so I can try to get some clarity here. How did you find your way to the board? So, like, why did you file this application? Like, what happened to instigate that whole process?
Because the owner of the property, they receive a citation.
Okay.
Because the cars.
What was that citation for?
The cars, they have a lot of cars on it, because the next building is a restaurant, and they have a lot of trash around and everything, and they'll find out that we have that service over there, the sedan service. So I have a citation for $500. We went to the court, and then we took care of, and then they told me that I need a permit to operate up there. But before they told us we don't need it because we don't provide any service that the people have to come to the place, so we don't need it.
But your actual use of the property is to be in an office and.
Yeah, but it's just me and my wife, that's all, nobody else coming in.
And you answer a phone,
Yes, sir.
so it's an office use, more or less.
Yes.
Okay.
Well, back to this photograph, you said the cars, why are the cars there? Whose cars are they?
Do you want to show them the photo?
I don't know how many cars you've seen
Well,
because.
yeah, there's 4 cars, and one looks like a stretch limousine, one looks like a,
Oh, the stretch limousine is ours, it's just one.
well, and the other 3 are all white vehicles that look like sedans of some sort. One looks like a truck type thing.
The van, it's mine.
Okay.
Yeah.
The
And
one
it's
that comes
it's
in.
a sedan service, right?
No, the van is my.
Personal
cargo
car?
van. Yeah, personal van. That's not the sedan.
Or what about the other 2?
That's the stretch limo that is
Mhm.
parking over there.
Yeah.
It's just one.
There's 2
The
more.
other one is we just wait until sometimes we have to jump or we wait for the tech. But right now, those cars, it's going out.
So you do have cars on site?
Sorry?
So you do have cars on site?
Only one.
1 plus your vehicle, that's 2, plus 2 more that we see there.
But there's not anymore. I mean, that's not there anymore. Just the limousine and the van, that's my personal car.
So you intend to park the limousine there,
Is it- that's it.
okay? And you intend to park your cargo van there?
Mhm.
And you intend to park any other vehicles that are awaiting registration or any other kind of
Sometimes for a week.
permitting?
No, but never more than 3 or 4 because, I mean, I don't know, I don't have many cars. I have just one under the company's name, in my personal.
So you don't intend to acquire vehicles to have drivers to use?
No. Every driver have their own vehicle.
And who runs the call center? I mean, who's there receiving the calls?
My wife and I.
Okay, so just the 2 of you, no other employees?
No.
Are you anticipating hiring any other employees?
Maybe in the future, but not at this moment.
Okay. Any other questions?
Nope. Thank you.
Okay. Thank you.
You're welcome. Thank you very much.
Thanks.
Thank you.
Okay, next we have 2018-336, 3327 St. Paul Street. Nate Prettle. So we have this listed as a request to use entire premises, expanding existing restaurant into second floor of property known as 3325 St. Paul Street, and add outdoor dining to front patio. Is that accurate?
Yes, it is.
Okay. If we can have all those who are going to give testimony sworn?
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Do we have any staff reports?
Yes, we have a letter from the Charles Village Civic Association. It's dated October 10th. They write that they support Major Tambra's Restaurant Incorporated, the application by the owner, Chris Shamaram, to expand the current restaurant into the entire second floor above the restaurant. Hours of the second floor restaurant would be the same as the current first floor restaurant, 9 a.m. to 10 p.m. on Sunday through Thursdays, and 9 a.m. to 11 p.m. on Friday and Saturday. In addition, the association supports the outdoor seating request for dining services by restaurant staff until 10 p.m., weather permitting. In December, the CVCA agreement with Tambor's Restaurant regarding operation and maintenance will remain in effect. We have a letter from Councilwoman Mary Pat Clark dated October 16th. She writes, I continue to oppose the further expansion of Tambor's Restaurant. My concern are Tambor's past practices, well documented with this honorable board.
What, I'm sorry, what was that?
Well documented with the previous past practices, business practices, complaints, things along those lines, with the honorable board. If granted, I ask that Tambor's representatives go on record as assuming full responsibility for the operation of the entire premises of their 100% now expanded residentially zoned premises and do not sublease any portion to any other persons or businesses. And then we have planning's report.
Could you pass the letter down?
Well, hold a second. She gave us 7 of them.
Thank you. Planning Department reviewed this application, noted that this property has in fact been in front of the board several times. The issue the last time around was that the previous zoning code essentially prevented an expansion as proposed today. The current zoning code does allow expansion of this neighborhood commercial establishment in the manner that's proposed by the applicant. However, the expansion will also, in the opinion of the Planning Department, trigger a requirement for 7 additional off-street parking spaces, as the current zoning code requirement states that no off-street parking is required for uses under 2,500 square feet in gross floor area, but this expansion will increase the floor area to an amount, to a total of 9,125 square feet, and therefore the excess above the first 2,500 square feet needs to be provided parking. On that basis, the department is recommending approval of the application, subject to the condition that off-street parking is provided to serve the increased number of patrons associated with the increased floor area of the restaurant. Thank you.
Okay. We'll hear from you, and if you could just in your presentation address the concerns of planning, that would be great.
Okay. I believe most of the board was not here when this previously came, and just to bear with me for a few minutes. Tambor's Restaurant opened about 25 years ago, and it opened in a building that was proven before the board to be originally constructed as a commercial use. Over the series of almost 20 years, the zoning board approved various expansions of that original restaurant, and we applied for a neighborhood commercial to complete what is essentially the top floor, second floor of Tambor's. We got approval for the half of the building, which was originally constructed as a non-residential use, but the board, I think correctly, the chairman pointed out that neighborhood commercial definition was limited to those buildings that were originally constructed. This building was a row house when it was originally constructed, and despite approval by the board, had not been originally constructed, so that led to a proposal to the city council, which was looking at amendments to transform Baltimore for various clarifications, to have the council amend transform definition of neighborhood commercial to not only have it applied, be able to apply to uses originally constructed, but also those buildings that had received prior zoning approval. And so that was a recent change that went into effect. We were prevented from applying to the board until such time as that did go into effect. It is now into effect, and as planning and your own staff report mentions, we now have, the board has the authority to approve the expansion. This building, one would, to look at it, would look at it as a commercial building. The top floor was an open space. It was even permitted, half of it, for an office building in connection with the business. But there was an unfortunate episode that Councilwoman Clark refers to, where a third party was leased the top floor for a nightclub. And both the neighborhood, the city, and the owner helped shut that down, and the space has been vacant since. So we're back today to complete the expansion, to use the entire second floor. One of the memorandum of agreement points with Charles Village speaks directly to Councilwoman Clark's point that he is prevented from having any third-party use of that. He has to keep it under single management, same hours of operation. And the neighborhood's been overwhelming in its support consistently. They were here at the last hearing, but you have their letter in the MOU. With respect to the outdoor space, in 2010, actually, the board did approve the use of that space. It's really on private property. It's not on the sidewalk. The tables are there in accordance with the board's decision. And it was approved for waiting for people that may not be able to get into the restaurant. We're asking that the board recognize that use and the tables can continue to be out there, but also be used for outdoor dining in the event that somebody wants to use it. We don't think that the neighborhood commercial aspect, which deals with existing buildings, should be interpreted to take away previously approved commercial uses, particularly on private property. And so we would ask the board certainly to approve the second floor expansion and the continued use of the first floor the outdoor space on the first floor. I'll talk about parking in a minute. If one were to look at where this is, there wouldn't be possibly a better idea of having sort of outdoor space and a vibrant mixed-use building. It's across from the Union Memorial Parking Garage, which we're going to get to. All the residents on the block have supported the outdoor seating and this before the last hearing. It is across from the Hopkins Bookstore and dormitory. It's the block to south of 33rd. Both sides of it are mixed-use commercial and outdoor seating. So we're certainly not asking for anything inappropriate and outside the character of that immediate neighborhood. Now, with respect to parking, at the last...
So it's presently a waiting area,
Yes,
and you're requesting service?
service. And the service would have to be, I think, there are no conditions recommended, but typically what service has meant for outdoor seating is that you have to be waited on by somebody. You just can't go in and bring beer out or bring food to it yourself.
Is the property right next to it commercial? It looks residential. That's a commercial space?
No, the property right next to it is residential. It's actually owned by the owner
Okay.
of Tambers.
And then are these residential as well?
They're residential.
Okay.
I have a petition, I think from the last hearing, that they all supported this.
The residents who live on this
Yes.
block
That's right.
support the outdoor?
Support the outdoor as well as the expansion. With respect to parking, about 20 years ago, I believe, the owner negotiated a arrangement with Union Memorial Hospital, which has a 500-space parking garage right across the street, to provide free parking for his customers. And we have evidence of the coupon books that he...
Whatever you're
Oh, yes.
saying,
Go ahead and
I
swear.
need your name too.
My name is Harkesh Kumar Sharma,
Spell that, please.
Harkesh, middle nation K, last name
Hold on a
S.
second. Harkesh.
Yes,
Slow down a little bit for the rest.
last name Sharma.
Is there any written agreement between the parking lot and the establishment that we can lay hands on?
I had it with Brad Chamber. It was 20 years ago.
Sure.
With the hospital, and since then we order them like each time, every 6 months, a year. I order them books. The parking garage they rent to someone, different company, so they send us books like 1,000 books. If I need 1,000 coupon, they send us 1,000 coupon. I pay them after 5 o'clock Monday to Friday, and Saturday, Sunday all day, because their employee leaves after 5. The parking is vacant, so I use them.
Okay, so the parking lot provides the
This
ticket
thing-
book?
Yes.
And with each ticket that your patron
have a
submits,
stamp.
they're giving you a bill at the end of the month?
No, we pay them first. So
Okay.
this is, we have a stamp, we employee stamp them, and that's like for 1 hour.
Okay,
That's only they stay, come and eat, they go.
so it's free parking for an hour, anything beyond that is at the expense of the patron.
Yeah, I mean,
Okay.
basically they pay for like 1 hour, and weekend is 2 hours. So they come in, we stamp on it, they have a time when they come in and take it. And when they leave with stamp out, they cannot, like when they leave with stamp out, they cannot go somewhere else and 4 hours later go there.
Sure.
Or they have a stamp.
And I would point out that all the immediate streets, both on the side of the business and along St. Paul Street, are all metered parking. So it's not something that one has to go several blocks before they find a non-meter, and then you get into the residential permit parking for Charles Village. So we think that, and we actually applied to the planning department many months ago when we first started this for a waiver of parking because the building's over 50 years old, which is another provision in the zoning code that seems to conflict with the requirement over a certain size. As I said, there's been no complaint about parking. Brad Chambers, there's a letter, not in this file, but there's a letter in the previous file from Brad Chambers, who's president of Union Memorial, in support of the expansion.
Okay. So is the waiver still pending, or has that already been denied?
It hasn't been denied, hasn't been acted on.
Okay.
It's not, I mean, sometimes you submit these and they want to wait and see what the zoning board's going to do.
Okay. Any other questions?
Anyway, Tamara's is a great restaurant. Hope you all, with or without the expansion, but hopefully get a chance to try it out. Been a great
Mr. Berry?
neighbor for 25 years.
I'm sorry, I'm gonna interrupt. With the neighborhood commercial establishment, where's the provision? 14328G says uses limited to building interior. All business, servicing, processing, and storage uses must be located within the building.
And
How does the outdoor seating par with that?
our position and argument to the board would be that that cannot take away a previously approved commercial use of the outdoor space. Under the previous zoning code, that use could have been approved by the board in and of itself and was approved in 2010. The patio's there, the tables are there. We don't think the board should look at that strictly and just take it away because of that provision.
But the board could keep what the restaurant currently has as an outdoor waiting area,
It could-
which is which is a much less intense use in a residential zoning district, and not authorize the expansion or the intensification of that use to provide outdoor dining at that site.
The board could do that. We would ask the board not to do that and consider the location. This actually, for the sake of argument, was proposed by the city planning department, that whole block to be commercially zoned. And it really acts as an extension of the Charles Village Plan Unit development, which is where all the Hopkins development, both on the north side of 33rd and south side of 33rd. It was proposed to be commercially zoned, and we would not be here at all. The councilwoman said no, she wants to keep it residential because of the previous concerns. So that started this saga. And then I again asked the board to allow the particular location of this as a recognition of an existing physical use, and the use itself is going to be limited to the MOU. Okay, thank you.
Thank you. Next, we have 2018-339-907 Fawn Street. Alex Barabesh.
Good afternoon.
Oh, okay.
Is that the one that was on consent?
Good afternoon. Are you Mr. Barabesh?
Yes, ma'am.
Did I pronounce your name correctly?
Barbash.
Barbash, okay. Would you raise your right hand and be sworn?
You swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. We have this as a request to construct a two-story rear addition, new fourth floor and rear decks off third and fourth floors. Is that accurate?
You should have had an updated sheet that the existing dwelling is to be widened on the first, second, and third story by 6'6", 60'9". I'll submit that.
Do we get this? Okay. Thank you.
The building was constructed in 1870.
Hold on one second.
Sorry.
Do we have any staff reports?
Planning Department has no comment on this application. Thank you.
Okay. The floor is yours.
Okay. The building was constructed in 1870. It's 148 years old. I have great concerns of building the extent of this type of a construction on a non-existent footer, okay? When it was built, it was sitting on a brick footer. So for that purpose, we want to, the existing building, as it is right now, is 20 foot 2 inches by 19 feet 6 inches deep in its original width. And then the building jets in 6 foot 6 on the left side. So what we would like to do is continue the original width of the building, that is 6 foot 6 by 60 foot 9 inches, and construct a proper footer for a dwelling of this size. The addition that is in the rear, which is currently 2 stories, has several trees that are growing in the back. That gives me great concern about foundation also pushing against the building. So we are simply removing, or we have intent, my apologies, to remove the 2-story addition and reconstruct a 3-story addition on a proper footer. Okay? And then the 4th floor would be built, obviously, to take advantage of the breathtaking views of the Baltimore city skyline. The other thing that I will add, besides the intent of building this building on proper footers, the extent of this renovation, because the building is 140 years old and it's 80 feet long, there would be too much disturbance to the existing brick, as the west wall is already bowing out quite a bit. The floors are not level, which is going to require sistering every single joist 80 feet long on 3 levels. That is going to be a huge disturbance to the existing brick. So that is why we want to take the correct approach to pour proper footers to support a building this size in nature. Okay.
Okay. Any questions?
Is this your residence?
Huh?
Excuse me, is this your residence?
It's going to be, yes.
Thank you.
Okay.
Calling next 2018-340, 5603 Narcissus Avenue, Juan Caseta. Welcome.
Hello.
Mr. Caseta, your case is actually on the consent docket. We have this as a request to construct a 2-story rear addition, is that correct? And we have already reviewed your request, and we have determined that the information that you provided to us already is sufficient for us to approve your appeal. So glad you made it. And if there's anything else that you would like for us to
No.
add to the record, we can do that now.
That's I have the drawings show the addition, and the drawings also show a deck to be built on the back of the building. If you already approve on my drawings, I should be fine.
Okay.
Thank you very much.
Thank you. Next, we have 2018-342, 3506 through 3508 Fleet Street, Nate Prettle.
Good afternoon. Back.
You again, huh? Yeah. You've already been sworn, so we have this as a request to subdivide into 2 lots, construct 2 new 4-story, single-family row houses with detached garages. Is that correct?
That is correct.
Okay. Now, staff reports.
Planning Department has no comment on this application. Notes, of course, that subdivision will require approval of the Planning Commission. Thank you.
Tell us about your project.
Sure, I'll try and be brief here. This is a vacant lot, approximately 34 and a half feet wide, on, again, 3500 block of Fleet Street on the north side. That's between Conkling Street on the east and Highland Avenue on the west. The proposal as listed is to subdivide this lot and construct 2 new single-family attached row homes. Each row house would have an interior courtyard behind the proposed structure leading up to a detached garage, which would serve for each property. And then there would be an additional parking pad in the back of that. These are unique lots in the sense that they're 150 feet long. I'm not here asking for any variances, and I'm not trying to speak to the variance standards. We're here to ask for a conditional use approval for the sort of limited 4th floor that's proposed. And I should mention that going by the conditional use standards, I think the 4th floor in this case will have as minimal of an impact as possible, and that's due to the 150-foot length of the lot. Each 4th floor will be set back 30 feet from the front property line. The north side of Fleet Street is a mix of 2- and 3-story homes. The recent property owner of 3504 Fleet Street, which is the property that abuts it to the west, was here this morning, or before the hearing. So he's very supportive of it, supportive enough that he decided not to stay. The reason he hadn't heard about it, we went through a community association process over the summer prior to applying for this, and he wasn't the property owner at the time. And I put him in touch with my client, who's the owner, the developer, and the builder, and I think 3504 Fleet, he's actually looking to do a similar type of improvement as this. And other than that, I don't have a whole lot to add unless there's any questions. I mean, this is something that I believe will be a positive development. It's across the street from a church. And about a block south of the heart of the Highlandtown Avenue business area and the urban renewal plan that goes in that. Again, there are no variances being requested, just the conditional use height, which is going to go up to 42 feet. But again, it's set back 30 feet, which the 150-foot lot affords us the ability to do that, whereas if it's a 60-foot lot, the 4th floor, the additional height feels a lot different than it does in a case where you're across the street from a 70-foot church, and you have the ability to mask or minimize the effects of the 4th floor.
Any questions?
I don't have any questions.
Thank you. Great.
Thank you.
Thank you very much. Have a good day.
Next, calling 2018-316, 728 Colorado Avenue. Nate Prettle and Mr. Barry, I'm assuming that you're going to take the lead on this one, too?
Busy day.
Okay, we have this listed as a request to subdivide lot, retain existing structure, and construct a new single-family dwelling detached with carport in rear. Is that accurate?
The carport's been eliminated. I'll explain that, but it is for a new single-family house.
Okay. Will all those who anticipate giving testimony raise your right hands and be sworn?
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do. Okay. Do we have any staff reports?
Yes, we have 2 letters. The first letter is from the Windhurst Improvement Association. It's dated October 15th, 2018. They write, on behalf of the adjacent neighbors and the Windhurst Improvement Association, I write to ask the zoning board not to grant the request of the seller and buyer of 728 Colorado Avenue to subdivide the lot, retain the existing structure, and construct a new single-family detached dwelling with carport in the rear. On the issue of nonconformity, it appears that the subdivision may create not one, but two nonconforming lots. Regarding side setbacks, modern single-family house placement assumes a centrally located structure with two small side yards. This was not the case 100 years ago when the original homes were built, and that time, homes were built on one side of their lot, often within a few feet or inches or on the property line, leaving one large lot side on the other side. Neighboring homes were placed on the same side of their respective lots so that even with little or no setbacks on that side, all the homes were separated from each other. But it is this very side yard, necessary for reasonable separation from the neighboring home, that this proposed subdivision is taking away from 728 Colorado Avenue. Let's see, the original home is a large three-story Queen Anne on a lot and a half double-sized lot of the other houses on the block. The large houses each occupy 100-foot wide lots, bookending on the west end of the block. The rest of the block contains more modest two-story homes within a slightly smaller scale with an appropriate lot size of 35 to 55 feet wide. As noted, 728 Colorado is at the west end of the block abutting Eddie's shopping strip. And this leaves an orphaned home perched on an inappropriate small lot right on top of a very busy alley with no opposing side yard to make it livable. Tuxedo Park is a large diversity housing stock ranging from small semi-detached in the R5 portion of our neighborhood to a number of large lots that would be more appropriately fit R1 zoning. Our concern, the large lots contain the most architecturally significant homes in the neighborhood. If we were allowed to subdivide this property with non-conforming buildings and located in a historic CHAP district no less, how can we objectively deny any future similar applications? This is a precedent that has the potential to cause significant harm to our neighborhood and should not be set. The subdivision in question is located within the Windhurst Historic District. No structure has been constructed in the 700 block of Colorado Avenue since before 1920. The current owner and proposed buyer developer have been very aggressive in their treatment of the neighbors. They threatened the adjacent property owner with no access to his property on the west side if he didn't cooperate. In addition, they called the owner of the home behind 728 that is divided into apartments an absentee landlord multiple times, after each being told directly by the owners that they live in the same block of Deepdene on which that house is located. For these reasons, the Windhurst Improvement Association requests that the variance requested by the seller buyers not be granted.
May I see that letter, please?
And I authored much of the letter, if you have questions.
Someone wants to see the letter?
I'm sorry. My name is Helen DeClerc. The last name is spelled D-E, capital C-L-E-R-C-Q.
Okay.
And there's one letter left from the immediate neighbor. They live at 724 Colorado Avenue. They write that their family resides at 724 Colorado Avenue, the property adjacent to 728 Colorado. We have been most directly impacted by the proposed request to subdivide. We had previously been assured by the current owner that the lot would never be subdivided. We therefore felt blindsided when the current owner asked us to meet with the buyer of 728 on 8/14/2018, and were told at the meeting about the proposed subdivision request. More surprising, however, was how we were being told. The representative of the developer led us to believe that we had been mistaken about our own property boundaries, He informed us that more authoritative information about the boundaries of our own lot than we had. He made it very clear that any access to perform maintenance on our portion of the west exterior of 724 Colorado could be legally prevented should this proposal be approved. Without any true survey evidence to date, this threat lingers. The proposed subdivision would profoundly affect our quality of life. In addition to direct evidence of construction, all windows of our home facing west would be dramatically obstructed, losing critical light and our view. When the zoning ordinance established the requirement for a 10-foot side setback, it assumes this would be provided on each lot for a total separation of 20 feet. Because of historical circumstances, our lot does not have any setback at all, consistent with the houses on our street. So this new house will just be 10 feet away. This is significantly different than the ordinance, the zoning ordinance, contemplated, and we are concerned about risk of fire. We therefore respectively request that this variance not be granted. That is the end of my reports.
Planning Department reviewed this application, noted that this property is contained within the Windhurst Historic District, which is a local historic district, and therefore the proposed construction is going to require approval by the Commission for Historical and Architectural Preservation. The applicant is already working in that direction. Separately, the department notes that the proposal is to divide a lot which has 100 foot of street frontage into 2 lots, and each lot would meet the lot area requirements. In addition, each building, the one that's already on the lot that would be remaining and the one that is proposed, would cover no more than 35% of the lot area of each of the lots being created. The details are actually contained in the Planning Department's report. The issue before the board would be the variance which would be created or necessitated by drawing a lot line that would be less than 10 feet away from the existing structure. Subdivision of the property requires approval by the Planning Commission, and that will include the development plan for the proposed new lot in addition to the actual subdivision line. The department is recommending approval of this application subject to the condition that all development of this property is completed in accordance with the subdivision, development, and architectural plans approved by the Planning Commission and the Commission for Historical and Architectural Preservation. Thank you.
Are those conditions acceptable?
Yes.
So why don't you tell us about your proposal?
Okay, so I'm here today with Sasha Keogh, who's one of the owners of the property, and Jeff Ott, who is a contract purchaser of the property. You'll hear from Mr. Ott in a minute as to his experience in home building and home renovation. And this particular proposal is somewhat unusual in that the lot that we're proposing to subdivide, which the neighbors are objecting to, really conforms in all aspects to the zoning code. There are no variances required for it. As the Planning Department's report indicates, we're not covering too much of the lot. And the only variance before the board today is created by a new side lot line that would be created to separate the existing house, which Ms. Keogh lives in, from the new house. And so that particular line could have gone potentially anywhere. And in fact, when we met with the immediate neighbors about this on August 14th, we pointed out that our civil engineer appeared to us to indicate that their building was built on the property, on their property line. And as you heard from one of the neighbors' letters, it's not an unusual development pattern in that neighborhood to have built on lots that were narrow. They were all set up originally as 25-foot lots to build to the property line, leaving a very small side yard between properties. We have some evidence and pictures of 2 houses in particular that do not meet the 20-foot standard that was argued for just earlier. So this is a situation where a homeowner and a contract purchaser want to buy the house, want to renovate the existing house and build a new house, and is required to go to CHAP to get design approval. CHAP, as you may know, is required to look at height, scale, massing. They don't approve zoning variances, but they approve the design. That design includes the building and landscape of the site itself. It's a rigorous standard to meet, and we have started to apply to CHAP. I have just an email, which I sent to Mr. Baumgartner, but he had already left, I think, for this hearing. I'll read it to you. That CHAP seems satisfied that we are in the right direction for this infill property. If you don't mind, I'll just read it to you and make it available as required. If I can find it. This is from Eddie Leon, who's a CHAP member. He says, "Dear Al, per our discussions, the new construction plans, we believe, are now headed in the right directions with regards to design. The site plan being proposed, apart from zoning and subdivision issues, appears to conform to the historic site pattern of the district. We look forward to receiving the revised elevation drawings for the upcoming CHAP December hearing." Were the board to have approved this today, we hope you do, and I'll give you some reasons why I think you should. We then have to go and submit a subdivision plan to the Planning Commission. They'll have to approve a development plan. CHAP will have to approve the height, scale, massing, and specific designs of the building. Originally, we presented to the board and the neighborhood, this was the house that was proposed, which had a carport on the back.
We have this.
So certainly in and of itself, an attractive house in keeping, if you have pictures of the neighborhood, in keeping with the neighborhood. We sent it to the Neighborhood's Architecture Review Committee. Their chairman told me they had no objection to this, but they could not speak for the neighborhood itself. CHAP, however, wanted to have a design which was more vertical. This, if you look at this, this is a horizontal bungalow style, maybe more appropriate in Mount Washington. Not that there aren't houses like this in the neighborhood, but the immediate block of Colorado is a more vertical style. The history of this property is also interesting in that there was a previous 2006 appeal by the zoning board to actually subdivide and create a lot just like we were proposing. However, at the time, that existing house next to it, Ms. Keogh was soon to live in, had 4 dwelling units in it. Her husband bought the property in 2006 after the zoning board turned down the subdivision, in large part, I would argue, because there were too many units. If you combined 4 units and 5 units, that was one reason for the denial. They bought the property, took out the 4 apartments, and converted it to their house. It's a single-family house, and as you've heard from planning, in conformance with zoning. Then, in 2007, CHAP approved, through City Council, a Winehurst Historic District. And it's an unusual district in that it concerns 2 disparate parts of the neighborhood, but one of which is along both sides of Colorado Avenue. And that requires us to ultimately get CHAP approval of the height, scale, massing, and the actual design. I'm disappointed that the neighborhood would send a letter like this because we reached out to them in early August. We reached out to the neighbors in early August with the set of the plans, and we wanted specifically with the immediate neighbors to say, before we apply for this approval, both subdivision or CHAP, we know that you have a potential issue because your building appears to be on your property line. And that's side yard, which you've enjoyed for many years, as long as you lived there. We have the ability to move the building. We can move it closer to the existing single-family house. We could work out an arrangement to deed some of the property to them. We could provide an easement so that there's not any misunderstanding about what might happen in the future if somebody were to buy it and want to put a fence right up on their property line. This was not a threat. It was a sincere effort to sit down with them and work out something before we came to the board. We also reached out to the Neighborhood Association. We said, we'd like to meet with you and discuss this. let me know what your concerns is. Is it the size of the house? Is it the height of the house? Oh, there was only 2-story at that time. And nothing, until we get the letters today by going to the zoning board and looking at
That's
their
not true,
file.
I met with you.
Please, please, you'll have an opportunity.
So no one's reached out to us to even talk about this, and I'm sorry for that. We believe that the neighborhood's own letter to you sort of testifies that this is a unique property in a sense of its location. It is right behind or in back of the Eddie's block on Roland Avenue. There's a commercial dentist office, I think, right behind it on Deep Dean Road. We are building something, or proposing to build something in complete character with the zoning. And we believe, and we'll have Mr. Ott talk about his experience, and if you want to hear from Ms. Keough as well, we believe that this, the zoning board can certainly look at whether or not the property is unique, should meet the variance standards, I'll go into that, but also the arguments that the neighborhood is making are really more appropriately decided and adjudicated at CHAP, because that's what they were set up to do when the neighborhood asked for it to be a historic district. Mr. Ott can talk about his experience briefly and then ask you to say something.
Hi, good afternoon. Al asked me to quickly talk about my experience. I've been doing real estate a long time, 25 plus years, mostly in the land subdivision arena for the national home builders. I left a couple of years ago to do it for myself and my family. I look at this house as, or this project as an opportunity to take a, turn of the century, early 1900s, beautiful house back to its old glory. There's a lot of work that needs to be done on the existing house, as well as build another great house for another great family to appreciate the neighborhood. That's basically as simple as it is. I think it's a great neighborhood, and I don't think this detracts from it at all. I think it adds to it. It brings a new life to the neighborhood. Thank you.
Thank you.
Just really quick, can I ask a question? So the picture that you provided of the bungalow isn't what it's gonna be? It's gonna be something that's more narrow?
We can show you a picture which we showed to CHAP today. We haven't formally applied to them. It'll be the same size. The house size will be approximately 2,300 square feet, but will not have a carport.
The width will be the same, it'll
The
just
width
be
will-
taller.
24 feet wide, actually. It's going to be a foot shorter.
Okay.
I don't know if you can see that. So that's the direction that we're going to head, because it's a 2-story with a front porch, which sort of
But no
marries
parking
with the
lot
neighbors
on the
better.
side? No, there's a car on the side, that's not there, obviously, right?
No, there's no driveway or anything on the side. That's
Okay.
just rendering at the moment.
Parking is off a rear alley.
Thank you.
Can you
I'll-
show, just
Oh, yeah.
give the opposition a chance to take a look?
Ms. Keough is going to wait and maybe respond to some of her neighbors' comments, just to see if there's any need for clarification.
Okay.
I have a question.
Yes.
The proposal is to redo or rehab your home?
Yes.
And have a new build. Will it be 2 shiny new houses versus the rest of the neighborhood that is a little more?
So the existing house that's there,
Yeah.
the architecture, the character will all remain the same. We'll make it better with paint and, that type of stuff. But the original house is going to stay. And then the new house is going to be obviously a brand new house. So yes, there'll be no altercation or alterations from on the outside.
Okay, we'll hear from.
So is there one person who's going
I would
to
like
kind
to
of
speak.
lead the pack, so to speak?
Yeah, I am Helen DeClerc. I own the property behind their house, but I'm really here representing the neighborhood. I was here for the last zoning meeting for the house before. Myself and Amy Bonnets led our response to the Transform Baltimore rezoning for our neighborhood and looked at that time, every single solitary lot in our neighborhood. And worked with planning really well. I was actually very impressed with how well planning was responsive to our neighborhood. I think, so when Mr. Berry talked about two weird chap districts, Windhurst is composed of two historic neighborhoods. One of it, everybody in Baltimore knows of as Tuxedo Park, which is where this house is located, on the west side of Stony Run. And then there's Embla Park by Friends School. And so there's a chap district in Embla Park, and there's this block in Tuxedo Park. Tuxedo Park was platted in 1892. It was composed entirely of 25-foot wide lots. Very few were built on 25-foot lots. It was a marketing strategy to allow customizable lots. So my neighbor has a 75-foot lot. We have a 50-foot lot, et cetera. And our house, by the way, is 22 feet wide. There's no reason their house couldn't be narrower than they're proposing. And they did very weirdly well, it's not weirdly. If you trust your neighbors and everybody's consistent, it works nicer. Instead of two small, not so useful side lots, you have a larger lot on one side, but it requires that everybody builds their house on the same side, right? And so here is a map from the Baltimore City's map showing this north side, which follows this unusual convention, and every single home is built on practically on top of the property line, okay? Now, I have a second one. Our modern setbacks are 10-foot setbacks for each house, so you should have 20 feet between houses. They're proposing a 10-foot setback next to a house that has no setback. So instead of 20 feet between them, you'll have 10. And the space in between the new house and the original one is 17, 3 feet short of 20. And so they talk about, well, we could move the lines over, but you can't move the original house. So if you do, you're taking away from that 17 feet, okay? Notice also that the size of their lot. It is quite large for this block, as is the one directly across the street from it. This house is just under 3,300 square feet. These houses range from 1,400 to 2,000. They are in scale with their lots. This is in scale with its lot. It's a very large Queen Anne that could be lovely, properly renovated, okay? We have a number of those lots throughout our neighborhood. But I think to chop this off and then pop a house right on top of its neighbors, 10 feet away, they will be just short of being able to lean out their windows and shake hands with each other, okay? And, that could be solved by them making the house much narrower, okay? But, so the side setbacks are not, we sort of assume a central location, right? But my own house, which is on a 53-foot lot actually, is within 6 feet of one property line. My neighbor that has a 75-foot lot is all the way on that side of his lot. So even though I only have 6 feet, I have a very large green space between my house and my neighbor's house. And as long as everybody cooperates with that, it works. And 120 years ago, maybe they thought everyone would cooperate. They probably quickly figured out that wasn't correct. But, the scale is a problem, but my other concern is precedent. If you look at our neighborhood, and because I worked with the zoning process so much, our neighborhood was a little bit of a challenge because we had along Deep Dean semi-detached on 25-foot lots. We have lots that are up to 125 feet wide on the southern end. Most of the houses on lots are about 50 feet wide and about 2-story houses. And so how will we fairly, okay, here's another map showing Gladstone. We have we were able to separate out the semi-detached into its own zone, and it's R5. The rest of the neighborhood became R3. We suggested R4 to planning, they suggested R3. But we couldn't do that with the large lots because they weren't contiguous, okay? And so the large lots are insufficiently protected by our R3 zoning, and that was just for the price we paid because of the way they're sprinkled through the neighborhood. But if I look at, I have this lot, I have this lot, I have this lot, how will we fairly tell these owners they can't subdivide? People confuse Tuxedo Park with Roland Park, and they come in here with dreams of glory. And I've seen a number of houses sit there for multiple years and they could not sell them for what they needed to empty. We had one in our block that sat there literally for 5 years, okay? Where the original renovator went bankrupt, gave it to the bank, and it just sat there. And I feel this is a very bad precedent to set. This neighborhood is 120 years old. We have had, that is literally 6 generations. We're the 7th, beginning of the 7th generation. We take this block, has had no mischief. We've had another number of places here where a house burned down, they put in a beauty parlor. You know, a weird apartment building's been built on some other block. This block is pristine. Every single house is the original house. There has been no damage done to anything on this block. And so are we gonna be the generation that messes it up, basically? Because the intent of the neighbors, what they told me, was to sell the original house that gets renovated and move. Okay. So their plan, they're gonna leave, and we're gonna be stuck with what's left behind, forever, right? This will go on in perpetuity. And we don't have a problem with the looks of the house. Mr. Berry continues to go on about CHAP. I actually trust CHAP will do a good job to make sure it's an attractive house. The problem is size. It just doesn't fit. They're shoehorning it into a space that's just too small. If that lot was 20 feet, 5 foot wider, even maybe 10 foot wider, it'd be reasonable. And especially they keep proposing houses that are wider than they need to be. My house is 22. The rental that I own that's right behind their house is 20. They're not proposing to put a 20 foot. They're putting like 24. You know, but they've got 10 foot and 17 foot when they should have 40. They should have 20 feet on each side, and they have 10 and 17. So our big concern is that it doesn't fit. The scale, the original house will look ridiculous, okay? All the emphasis is on the new house. But the original house, which is this big, huge Queen Anne, is gonna be trimmed up of any useful yard. Oh, the other issue is the original house is right on Eddie's Alleys, which has big trucks parked there doing deliveries and all sorts of traffic all day long. You're now gonna take away the only yard it has. It's just, it's not gonna look right, it's not gonna make sense. I mean, it's just, and that's why it's hard to negotiate with them, because we can't make more space show up. You know, we can't wave a magic wand and make more space show up. You know, and that's, space ultimately is the major problem.
Okay, thank you.
What's the distance between these two houses?
That is on Colorado.
In Colorado, yeah. Right here.
These two, I don't know, this house is a little crazy, right? It's like on both of its property lines.
I was actually talking about the,
This one here, I know, this is the house is a 75.
I was talking about these two right here, this one.
The narrow space.
Yeah, that's probably something like smaller than it ought to be, especially if there's a fire, right? But 120 years ago, you didn't make people do things sensibly. That's why we have zoning. 120 years ago, they didn't have zoning. You could do whatever almost. But even so, notice they're all on the same side. And if you looked at Deep Dean, all those houses are on the other side. And as long as you're consistent, you at least have some space. You put this and you stick a house right here,
Yeah, we can see that.
you know.
And in your letter, I think you may have touched on it, but I'm not sure, under scale, the last sentence, say, to reduce the lot by half, and in particular to do so by trimming off the interior side yard to the east.
Right.
Then in bold, it has leaves an orphaned home perched on
Right.
an inappropriately small lot, right on top of a very
Because you
busy.
need to understand, this home is 33, it's 3 stories, and most of these homes are 2.
Yeah, but what does that mean? Right
I
on
mean,
top of a very busy
to
alley
me,
with
I
no appro-
imagine-
Would you let me ask the
Oh,
question?
I'm sorry.
Leaves an orphaned home, I'm not sure what that means, perched on an inappropriately small lot, right on top of a very busy alley with no opposing side yard to make it livable.
Yeah, there will be no outdoor space for people to use who have this house. This alley right here is the Eddie's block.
Yeah, I know.
And so this is very busy. School traffic in the morning is a little crazy there, but we constantly have very large 18-wheeler delivery trucks back here. It really needs a wall, you know, but that'd be expensive. So this space on this side really isn't usable, livable space, outdoor space. This is the only really usable outdoor space that house has. And you're gonna take it, pretty much all of it away.
So you're concerned for her benefit?
Not just her benefit, but if you know, the house won't look right. And I'm not concerned for her benefit because frankly, what they told me is they're gonna move.
Thank you.
I have 2 quick questions. You said that, how long have you lived in the neighborhood?
I've lived here since 1998.
So you participated in the last time there was a request before the board
Yes.
that was denied?
Yes, very much so. And while there were concerned about the fact that it's multifamily, that wasn't the only concern.
Well, okay. And then, are the direct neighbors here? What's the distance between your house and the other house on the other side of you?
Probably 20, 22
Sir.
feet.
You can't.
Oh, I'm Paul Giggy. I'm not sure, but it's
Paul Giggy?
yes, Giggey. I mean, it's pretty far. It's a yard. It's we've never measured it, but it's probably 22, 25 feet. That's just a guess. We've never measured.
Are there, Mr. Baumgartner, are there any notes from why the past request was denied?
The prior BMZA appeal, which for the record is 41506, they had a different numbering system back then. It's very, very short. That's why it's okay to read it into the record. It says, the board, in making its decision to disapprove this appeal, finds that the proposed subdivision would change an existing complying conditional use to a non-complying use requiring variances to the minimum lot area and yard regulations. The board finds that the conditions on which this application is based are not unique to this property as compared with other property in the area. The board cannot find that because of the particular physical surroundings, shape, or topographical conditions of the lot, an unnecessary hardship or practical difficulty would result if the strict letter of the regulations were carried out. Therefore, based on the findings and facts, applicable laws, etc., of the zoning code, the board disapproves the application.
And I'm the only one here who was actually in attendance at that meeting. Everything else is speculation.
Okay, well, it makes sense for you to
Yes.
continue since you just
Hi,
answered
I'm-
a question.
Paul Giggy. A couple of things. I mean, I wrote a letter, which, I don't want to waste your time in revisiting, but I do want to correct a couple of things. When we met initially to talk about this, it was presented as this is a done deal by somebody who was very experienced and does a lot of these. You can go to neighborhood associations, they can go, but by and large, those are not really counted in these this is the way it was approached. So we were told very politely that our property line, our house was actually, the words used were on our property line. Those were the words, not ours, theirs. And I don't know anything about zoning. So my wife Amy and I had to sit and go, oh my God, what if our house is on their property? That was exactly how we were left. And therefore, I think this is appropriate to be discussed here and not in CHAP. So far as our concerns as citizens is that a developer could come up to a lot next to your house and go, hey, where you think your property line isn't even your property line, and apparently you can get this far without, and I'm frankly reluctant to have a survey done, but there's a property marker, there's a small fence, and there's a hedge that's been there like 100 years that apparently is, that we have been led to believe, and we don't have anything official. But I think that's, in and of itself thus far, has caused a tremendous amount of stress in our household. And hardship is interesting. That's the words in there, because when I think about what happens next, when we have this thing come 10 feet, that's 10 feet from we don't even know where the property line is. So 10 feet from where? I asked when we met, what if our house is 1 foot, 2 feet to your property? We couldn't get an actual answer. And in fact, what I heard later on was, oh, we didn't say that at all. We never implied that. And the second thing in that, as far as communicating with us, there was nothing to communicate about. We were led to believe that this was going to happen. Our say didn't matter. And it is true that afterwards, Sasha reached out to my wife, and we did respond. We said, we can't approve of any approval. I can't approve of anything. Number one, the approach is a little rough, I think, a little intimidating. We're all off of work to be here today. So I can't approve of anything. There are so many ways to approach this, and now we're faced with it feels like a steamroller to our house. we were told, we moved in, and we never looked it up, but we were told it's the very first house in Tuxedo Park. That's what we were told by the association, because we had to change some windows. If that is the case, this changed dramatically, the entrance into Tuxedo Park, because there's a lot. You can see our house from far away. We have much of the windows, and the view of our house goes straight up, to Roland Avenue. We lose all of that, aside from, the ongoing construction, and then there are neighbors right there. And then, in terms of hardship, if you think about, you look at those plats from above, when someone goes to sell a house, suddenly now our house is worth less because it doesn't have the same green space on either side. And in fact, in fairness, I think if this were subdivided, you've done that to 3 lots. You've caused a hardship to 3. The White House I don't know how anyone would purchase that house if it were subdivided and had no space in front of it. So, and I could go on, but I just wanted to convey, this is significant. It's really scary for us. I have no idea that a developer could just go, hey, that's not your property. And you go, and what the words Mr. Berry used was, this was county back then. We have documents that supersede this. That's really scary. The neighborhood's like, hey, maybe you should get your documents. You could always get a survey, but why would we go through this? I'm sorry. But from our perspective is, I don't think this is something the city should reward. And I think us personally, it is an undue hardship, but it's not all about us. I think Helen DeClerc's comments about the community, I'll say this, in the meeting, among Don Keogh's last words to us was, yeah, I bought this and I bit off more than I could chew, and I'm really sorry. And Don's a great guy, he's a nice guy. But that's what he said, I'm really sorry. I'm sorry I said it wouldn't, he didn't say, but he had told us previously he wouldn't subdivide. He said, I'm sorry, we're selling, I'm done. Well, I think that's a really terrible thing, a way for us all to be talking about this, is it's just something that's the benefit, that Don and Sasha sell the property, this developer can make some extra money, but that's really, how does that weigh against the effect of the multi-generational quality of our neighborhood, all of us who I think are the surrounding neighbors, and us next door who I can't imagine what light, what changes for light, or our house is covered with it's a cottage, a little Roland Parkey cottage thing. What if there's a fire? That house is that close? So there, and so on. But thank you. Our position is will present a phenomenal hardship on our house. Thank you.
Let me just ask a question very quickly. Has a survey been done on your property to boundaries?
We haven't been able to find an old survey, and I haven't done a survey for the plat yet until we had this meeting. But I do have proposals ready to go to get surveys done quickly.
And as part of the subdivision process, to get that far, we'll require a full survey and any other encroachments that may or may not be there.
Are you?
Just to say that
You have to step up and give your name.
Steve Oxman, I also own the house adjacent to where this construction is proposed.
What's the address for your property?
727 Deepdene.
Okay.
I just want to say that the community association is unanimously against this. It was a unanimous vote. Everyone on the board is against it. All the neighbors that are adjoining or adjacent to the property are against it. CHAP is unable to stop new construction that isn't within their parameters. Their parameters are only if something is built, it has to be built a certain way. So them going on and saying that CHAP thinks it's cool is not really the case, and not really the proper way to paint this. And I believe it is being painted. And I believe this is a 100-year-old neighborhood, and there is no way that what is going to be built is going to be a 100-year-old house. It's going to be a Disneyland version of a style of a house that may be an old style, but in fact it will ruin what is only a one-block historic district in our 6-square-block neighborhood. Only one block we felt had historic value that we wanted to preserve, And that is the block that they've determined they would like to build this brand-new structure, which will, in fact, ruin any historical value to the block, of the way it's set up, the way that we're talking from 100 years ago when people came up from the city to get fresh air. It was a new thing. I mean, and that was part of what makes the charm of our neighborhood, is the old growth trees and the green space that we have. We don't really have a park. People have yards. I mean, so it takes away from everybody a little bit. But I just want to say that it's unanimous in the neighborhood, and that the president has signed this, and that the chap has an inability to go against the new construction. They haven't even been given the plans for it, mind you. Thank you.
Okay, thank you. Anyone else from the opposition at this point?
I'm John Dugan. We're short timers in the neighborhood. We moved in last year. We've got the best view of the house, which is beautiful. Likewise, I think its historical context exists within the context of the lot, and I'd be disappointed to look out the front window and not see. That was one of the things that sold us on moving into this neighborhood. So,
Your house is across the street?
733, we're right across the street. We're on a double lot.
See it. Thanks.
Thank
We
you.
have a badminton net for the kids to play badminton on the side. That's it's space for kids.
Thank you.
That's his alley.
Before summing up, I'd like to have Ms. Keough maybe respond to a few of the comments and then reiterate some arguments why I think the board can approve this and frankly should approve it. Ms. Keough?
Spell your name for me.
First name is Sasha, S-A-S-H-A. Last name is Keough, K-E-O-U-G-H. Just to reiterate a couple of the points that were presented by the opposition. With regard to the neighborhood association, we were never given the opportunity to present to the neighborhood association. We reached out to them, we reached out to our neighbors, and there was no opportunity. We weren't invited to any of the meetings or meetings that were held to discuss this. And one of the things Ms. DeClercq mentioned was a narrower house. And I think, I can't speak for Jeff, but I think that if that had been brought to our attention, we could have maybe, before now, we could have maybe worked on that, because we've asked our neighbors, definitely the Giggies at 724, several times to engage and discuss with things they might like for the side yard or for the property. And as they mentioned, they did not respond and indicated that they could not respond at this time because they didn't know the property line. One of the other things that Mr. Clark mentioned was our backyard. And it is fairly deep. I have 2 kids and a dog, and there's plenty of room. We currently now have a play set in the back, right in back of our house, would not be impacted by the building of the new property, and it's fairly deep, and that would, to me, be more than a sufficient yard for a house of the size that we live in now. Just one second. When we met with our immediate neighbors, the Giggies, the first time, I disagree that it was presented as a done deal. If anything, we asked for their input continually at that meeting, and then we had an open house a week later. And then after that, I reached out to Amy Giggy a couple times by text. I have copies of those if you would like to see them. And one thing that Mr. Giggy said was that we indicated to them that we would never subdivide the property. And again, we didn't say that. That was not the original intent when we first contracted with Jeff. We weren't aware that that was part of the plan. And when we became aware, we immediately reached out to our neighbors, the Giggies, and said, we'd like to talk about this with you. We'd like to meet with Al and Jeff and you and discuss our options. That's how it was presented. And in the letter that they wrote to you or to the commissioner, they indicated that the first time they heard of it was when we met with them, and that's not true. They were made aware several days prior on the phone when we asked to have a meeting with them. I think that I don't want to take up any more of your time. I think that's all I have. Okay.
Will you continue to reside in the house?
If we get this approval, no, we plan to sell to Mr. Ott.
Thank you.
Thank you.
Try to be brief, but I think it's unfortunate to have to come to this. I think the old zoning board appeal decision, which I read, really is not applicable here. At that point, they were looking at the side yard for a multifamily building as opposed to a single-family building. At that point, the side yard required was 15 feet. Now it's a single-family dwelling, it's required to be 10 feet. We're asking for a reduction from 10 feet to 7. As I said, we had some flexibility. Had there be some dialogue, perhaps in the CHAP process, if it gets that far, or the subdivision process, that can continue. The options we put on the table, and again, we did not have a survey, but it looked to us, and I think their own evidence indicates that many of these buildings were built on or near the property line. And I suggested to them that now was the time to solve this, either through an easement, through a re-subdivision, to deed them some property. I will point out to an existing house down the block, which is 11 feet apart. And the evidence you've seen on Colorado, other streets in the neighborhood show that this is a historic pattern. All we're asking to do is sort of infill something that is meets zoning, that will be subject to CHAP's rigorous review. I think it's an insult to CHAP to all of a sudden have the neighborhood ask for historic district designation and then go back and say they don't trust it because it's going to be some Disneyland recreation. I don't think that's fair. The materials that CHAP requires are substantial materials. They don't allow vinyl siding, for example. The design of the house is still flexible. We've already shown you one picture of a more vertical looking house. It's going to be a foot narrower apparently. So we're asking the board to look at this unique property by several testimony by the neighborhood showed it to be a unique property, given its location of commercial uses, given its size, and to put their judgment as to who might want to live in that large house because of a house next to it is really unfair, and it's not something that the board should even take any note of. We believe that planning and looking at it, CHAP's given us initial indication, those are the venues to really address what the neighbors are complaining about today. And we think that I would ask you to not use the previous disapproval for an entirely different proposal. Give the Keoghs some credit for converting a multifamily absentee-owned property into a home ownership single family. Mr. Ott's going to renovate that into a substantial single family property, put up a small scale house next to it and consistent with the immediate neighborhood. And to say that because we're historic 120 years old, if you take that argument to any other historic neighborhood, Fells Point, Canton, you would not allow any buildings, infill buildings on properties. This whole neighborhood was built with infill buildings. I grew up in this neighborhood, frankly. I know that there were buildings built, which is one reason why the neighborhood wanted to make it an historic district, to sort of control what happened to existing buildings and any future buildings. So with that, I'd ask the board to, I think we meet the uniqueness standard. I think we meet the fact that we're meeting zoning codes. Zoning codes and setbacks are designed to deal with light and air. I'm sorry if a neighbor looks out of the yard and enjoys that for many years, but that doesn't mean that the property right of the owner should be taken away to build something that conforms with zoning. I don't think that would be a good precedent for the board to set either. Not that you know, every case is different. I respect that. So we'd ask you to approve the minor variance. We could have, if we had 1 foot difference, this would have been a minor variance. Could have been just gone to the zoning administrator. We tried to keep the lots at 45 feet or longer, which is in accordance with zoning. The lots on that block go from 30 to 33 to 40 to 50. They're all over the place. This is not going to disrupt any kind of development pattern for the neighborhood. They asked the board to approve it, obviously subject to planning department's recommended conditions.
Sure. Okay, thank you all.
Thank you.
Eastern Avenue thing, something we have to.
Yeah. Don't go far, Mr. Barry. 2018-323, 1000 Eastern Avenue.
Is this the last one?
This is the last one. We have this as a request to use as 30 dwelling units with first floor commercial, amending BMZA 2018-323, originally approved May 29 of 2018 for 26 dwelling units with 2 floors of commercial spaces. Is that an accurate description of this proposal? If all those who intend to give testimony can be sworn.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Do we have any staff reports?
Planning Department has no comment on this application. Thank you.
Okay. So tell us about your proposal.
It's maybe ironic that all the ones that we've talked about today have a history, as is this. And in 2017, the owners who are here, applied for a 6-story, 75-foot, or at that point 70-foot tall building for 30 units. And there was opposition, substantial opposition from the Little League Association and Formagia of Blatterman, and the board denied the appeal. Prior to this, this property was a nightclub, rather infamous nightclub, that the owner and the Little League Association had to shut down. The nightclub itself was run by a third party. It became problematic to the neighborhood, and with his effort, just canceled the lease, padlocked it, and it became, that was 4 or 5 years ago by now. 6 years ago. At the time, that property was zoned industrial. And there was a new zoning code. He was interested in redeveloping it for a small apartment building like this, but was told the zoning's going to change. The zoning's going to change. Transform Baltimore is right around the corner. Well, it took until 2017 to have Transform Baltimore go into effect, which is when we applied for the appeal. At the time, we met with Councilman Kraft over the zoning, what was going to be changed from industrial to either C1 or C2. We had, frankly, support by the one of the neighborhood associations for this building. Councilman Kraft, unfortunately, in rewriting the zoning code, didn't give us enough units for 30 units by right, but required us to go in for a variance. That was denied in large part, I believe, because of the opposition at that time from the planning department, much less the neighborhood association. Well, we came back in 2018, Appeal 218-147, and as was noted, we were approved for essentially the same size building. At this point, it was 75 feet tall, but still 6 stories. And because we could not reapply for the same use within 1 year of the disapproval, we changed one of the floors, the second floor of the apartment building, to what was permitted by right, which would be a commercial office. So we had first floor retail, lobby, second floor office, and 24 units, essentially in the same size building. That appeal was accompanied, after working very diligently with the Little League Association, with an MOU, which basically puts the burden on the owner to get this done. And to get it done by getting his permits, getting the building down, and that was approved by both parties on May 29th of this year. Once the October deadline of the year previous disapproval passed, we had told everyone that we would come back, because really the financing is really tied up with a 30-unit building. So we needed a placeholder so the bank wouldn't take the property away, because no zoning approval was required. And we can talk about that if you like. Just this afternoon, I believe you have a copy of a revised, it's the same MOU, but it's dated as of today. I don't know if that's been made available to you. You can pass it around, or I can also, I don't know if you have the new one or the old one.
Yes, it's made.
We have the old one.
May
Okay,
29.
well, it's the same MOU, but with, signed with today's date.
Okay.
And we're glad that the association supports this. We're glad that planning has changed its previous position of disapproval to no comment. This will have to go to the planning department for design approval. It's one of the new buildings that falls under Transform Baltimore. And so they'll be involved. I don't know if it'll go to the planning commission unless we have or UDAP for that matter. That'll be up to the planning department. With respect to parking, the MOU speaks to that. This building is adjacent to a city-owned parking garage and 2 blocks away from another city-owned parking garage. In meetings we've had with the parking authority will provide leasing of 2 types in either garage. And this type of building has already been found to be on a site that's unique to the neighborhood. It's across from another 6-story building on Eastern Avenue. And we think the number of units is relatively small, and while the percentage of zoning variance might appear to be large, there's no standard in the zoning code that really sets a limit. The old zoning code, you can only increase the number of units by 25%. The new zoning code doesn't give a limit. We're not trying to be excessive and build a 20-story building here. We're actually asking for 6 or more units as part of your original approval within the same envelope. And we would hope that the board can approve this today and amend the previous approval and let us get started so we can comply with the MOU, get it done. I'll also just point out this, if you've looked at Little Italy lately and all the new developments that are either under construction at the corner of literally a block and a half of 2 blocks away from this. We're talking about 30-story buildings, Inner Harbor East, 20, 25-story buildings. So the amount of units in this case is relatively small, and it will remove a abandoned, vacant nuisance property, which is what the neighbor is really concerned about.
Anything further from the appellant?
Nothing further, sorry.
I guess. I'm in support of redevelopment.
Your name, please?
Oh, I'm sorry, Michael DiCicco, D-I, capital C-I-C-C-O.
Okay.
I'm in support of redevelopment of the property. I'm here because of the timeline that he had mentioned all the ways through. I thought 2017 happened in 2018. The zoning board, you guys disapproved it with 30 units in 2017. I missed the meeting where it was changed to 26, but I could have swore I saw 24 units for this building. I don't know if it was off of your side or whatever, in my head. And I'm curious on how it was approved for 24 or 26 apartments in May of this year. Now here we are, September, and they're reverting back to 30 units that was already disapproved, say, a year ago. And I'm having a hard time, understanding that part. If it was disapproved one time, why can it be approved a second time? The MOU, I saw a copy of it today for the first time. I was under the impression the parking that is being offered is for the Eden Street garage, not the Little Italy parking garage, which is right adjacent to the building. But you're going to put these units up, and if my scenario is correct, the people who rent these apartments have to go 2.5, 3 blocks away to park their vehicle. We know they're going to wind up being on the street because enforcement is very lax in the area, but they're just not going to be able to get decals and or visitors passes so they can legally park on the street. They're just taking a chance. So once again, in support of the property, but very confused on 30 units being turned down. Now all of a sudden 30 units is acceptable or is trying to be changed. And that's basically what I'm here for.
Okay.
If it makes sense to you, if I explain.
Some light, Mr. Barry.
Okay, the zoning code, the old code and the new code have a provision that if the proposal is turned down, you have to wait a year to come back with the same proposal. So in this case, the disapproval, which we were disappointed at, for the original 30 units, again, large part because of the planning department, large part because Little Italy's opposition. We have a new board members, many new board members, not all. And we believe that the parking, you're right, the Eden Street garage is adjacent, is the garage that you can rent a space. If you get in after 5 o'clock and leave by 9, you can rent a space for $40. And so some people will do that. If people want to live here and want to, take their car because they leave and they can park there on weekends, they'll do that. If they don't leave at 9 o'clock, they get charged the daily rate. But the monthlies will be at the Little Italy garage. And that's going to be whatever, give 24-hour in and out privileges for it. Those are the two options that the Parking Authority has given us. And we think that some people may want to live downtown, may want to park their car. They can't park it there 24/7 next door, but if they don't use the car, other than on weekends or whatever, they'll park in the other garage. You've heard that you can't get parking stickers, can't get visitor passes. Yes, people might be able to, move their car around, but for convenience, realistically, they will park in one of those two garages where there's an abundance of spaces. We're glad that you're here and somewhat in support, and it's really more questions than anything else. I hope the board can go ahead and approve the small additional number of units and allow the MOU and the demolition to proceed expeditiously.
Okay. Sure.
What your name, sir?
Hi. Sean Shepard.
Sean
S-H-A-H.
Last name?
Yeah.
What's your?
Sean, S-E-A-N.
Sean Shaw.
Yeah. My comment is that, if Michael has a concern about the parking, which we already, resolved with the neighborhood, having a one-floor office building versus adding 4 units in the residential is by far gonna get the less parking with the residential than having one floor of the office, which you could have 30, 40 employees. Therefore, that by itself will help to reduce any kind of parking concern that they might have. And we've been through so much to get the neighborhood approval and get the neighborhood support unanimously, pretty much. Everybody approved us based on the memorandum that we signed, that we are gonna stick with it. I appreciate your time. If you have any question, I'll be glad to answer. If it's not, I appreciate your time.
Any questions?
I would just briefly add, though, Mr. DeChico's concerns are shared by others, that the board denied an appeal in 2017, not based on agreement with neighbors, but based on the substance of the appeal for 30 dwelling units. That application was amended to reduce intensity of the residential component, which was a new application that came before the board, and that was approved. And now we're back here again requesting the same relief that was denied in the first place. So I think, not to put words in his mouth, but I think that's a concern shared by others,
But as I said,
that, as to why we're back here in the first place.
What are the notes about the denial? Are there any? Or what does the decision say about why it was denied? We can discuss this after. We don't do it now.
Sure. The resolution is not particularly long, but it's long enough, but that we can certainly
Okay, look at it.
go over the board's resolution.
Deliberations.
I just comment that it is a new board, and it may seem that it's a short period of time, but the zoning code does provide for you to apply for the same use within at least a year after. I think the board, in making its findings as to the uniqueness of the variances before in May, certainly applies to this. And changing a floor of offices for a floor of residential will have less impact on the neighborhood. Certainly the neighborhood knew that maybe the board didn't, but the neighborhood knew that the idea of having to go in May for the smaller number of units was really to satisfy the lender who's got the property, so that it wasn't taken away from him, that there was progress. He had some use of the property. And now, in trying to get financing for all of this, they really want an all residential building, not a mixed-use building.
But because it's in a C1 district, those commercial and office uses don't trigger, they're allowed by right.
That's right.
So they wouldn't have come before the board anyway.
Right.
and because of the way that Transform was drafted, they don't have parking requirements, they don't have square footage requirements. You know, so the intensity of use might certainly be more or less, but under the code, the residential units require nearly 50% variance, and all those commercial uses which were approved under the prior appeal would have been allowed by right. So I just want to.
But I think it's a fair to look at, rather than the degree of the variance, because of the small number of bases that you start from, that it really doesn't have much of it, if any, impact. And the building envelope comes about in some part because of the Transform Baltimore's requirements. When you build a mixed-use building, you basically have a certain floor height from the first floor to the second floor for retail use, I think 14 feet or at least, as a minimum. And then these are going to be listed with 10-floor ceilings. We want this to be a luxury building and 9 or 10-foot ceilings, which get you to the floor, which gets you over to 60 feet that the zoning code sets as a limit. You have to go above that, which we did, and the board approved it. That's to 75. So in all, the renegotiations with the neighborhood, the change of planning's position from opposition to no comment, the fact that they're going to have to approve the design of it, I hope that's sufficient for the board to approve this today.
Okay,
Thank you.
thank you all.
Thank you.
And we are off the record.
Boy.